Okay. Good afternoon, everyone.
Good afternoon.
So today is the 9th day of August, 2021. We are continuing our lectures on Nigerian company law, and we are looking at membership of companies. Okay, so I will just start by giving us an introduction. Every company must have members. We cannot have a company without members. The company is an association of persons. A company is an entity that establishes because private individuals have decided to organize their entrepreneurial endeavors or their endeavors around it. The company is not like a statutory corporation which doesn't have to have members. Priya, are you with me?
Yes, sir.
Yes, so a statutory corporation like NNPC is not required to have members. It is owned by the Federal Republic of Nigeria. It is a direct agent of the Federal Republic of Nigeria. When we come to the company, on the other hand, we've already established the fact that it has a separate legal personality from its members. And so it is not an agent for its members. It doesn't own or hold its properties on trust for them or as an agent for them. It has a life of its own, if you may use that word. But the law requires that that company must have members who associate around it. Are you with me so far?
Yes,
and so there's now a legal framework which we want to look at. A legal framework for membership. Who is qualified to be a member? How then can we become members? So those are the things we want to look at. Who is qualified? How can you acquire membership? What are the liabilities and rights that come with membership? How can we prove membership? What obligations attend to membership? So those are the things. Stop making noise. Those are the things we want to look at. So who is qualified to be a member of a company? How then can we acquire membership? How do we identify who is a member? How do we prove and establish membership? What are the rights of membership? What are the liabilities or obligations that attend to being a member of a company? Are you with me so far?
Yes,
excellent. So now on a general note, we have already pointed out that we have two strands of companies. We have companies that are set up for profit-making purposes, which I have chosen to call share capital companies, because the persons who invest in such entities are entitled in law to participate from the profits of such companies in the form of dividends or any other related form. And the interests of those persons are reduced into shares. And so company law calls the capital of such companies share capital. We also establish the fact that we have non-share capital companies because for such entities, even if the members bring in funds, they are not entitled to participate in those funds. They are not entitled to participate from the profits that those companies may make. And so for such companies, we call them guarantee companies because with respect to liability to third parties, the members of such companies will still have to bear liability to the extent to which they have undertaken to pay. And so we have these basic strands of companies. Now for the share capital company, the major ingredient, the major factor that makes you a member is your share. As long as you have a share in the company, you automatically have a right to be a member. For the guarantee company, the major factor that makes you a member is your undertaking. The guarantee you make that in the event that this company is going to be liquidated during this particular period, I have undertaken, if this company is indebted to A, B, C, and D, to contribute the sum of 1 million naira, 2 million naira, and so my liability is limited to that extent. Are you with me so far? So I'm trying to establish what we've already known, that these are the two basic strands of companies which we have. And so when we begin to look at membership, we will have to, from time to time, draw the distinction between share capital companies and non-share capital companies. So who is a member of a company? First of all, you want to look at section 106 of CAMA, which first of all tells us who are the members of a company. Section 106 of CAMA. First of all, we have what you call deemed members. Deemed members. So for every newly incorporated company, like we all know, the memorandum, every newly incorporated company, like we all know, the memorandum of association must be signed by all the members. Zebi, you remember that? You remember that? And so all those members who sign this memorandum are deemed in law to be members. The moment you subscribe to the memorandum of a newly incorporated company, whether it is guarantee or non-guarantee, the law deems you to be a member. And by deeming you to be a member, it now imposes an obligation on the company to enter your name into a subsequent document called the Register of Members. Callistus, are you with us? Yes, sir. So that is the first group of members that we have, deemed members. Secondly, the second category of members we have are persons who subsequently, after the incorporation of the company, now become members. For such persons, they must agree in writing. They must agree in writing to be members of the company. And having agreed in writing to be members of the company, their names will also subsequently be entered into this register. So in both cases, the names of these persons who are members of the company must be entered into the register. For the first category, they don't need to enter into any separate agreement with the company. By simply subscribing to the memo, the law deems them members. So if you look at the Memorandum of Association, I don't know if you have seen a draft of it. If you've not, I can send you one. Will you like that? Yes, sir. Excellent. So you will see that there's usually what is called a jurat. A jurat, J-U-R-A-T. It's more like a table. It's more like an explanation. You know, so a jurat is an explanation. We, the following persons, have agreed to become members of this company. And we have agreed to take in the following number of shares written against our names. Adigio. Your name, is there one mate in your name? No, my daughter. Adigio, what is the other your name? Jennifer. Good. Jennifer Adigio. You see against her name, 200 shares. She will sign, she will date it. Walson, 500 shares. He will sign, he will date it. Are you with me? That is the jurat. So the moment they all sign that document, and the memorandum is registered with the Corporate Affairs Commission, they will have deemed them to be members. So they don't need to enter into a separate contract or agreement with the company. That's what we are saying. But apart from these persons, these initial members, whose names are entered into this memorandum, these who subscribe to the memorandum, every other subsequent member must agree in writing. Are you with me? Agree in writing, after which their names will still be entered into the register of members. So they become a member. So we have deemed members, and then we have subsequent members. Can we continue? Yes. I said section what? 105. No, it's 105. Not 106. 105. And I pointed out that for every share capital company, every member must have at least one share. Did I point that out? Yes. Abi, are you with us today? You're not there. Okay. If you want to go, you can stand. You go to the back and stand. It's allowed. Okay, so for every share capital company, greet auntie. Good afternoon, ma'am.
Good afternoon, ma'am. We are happy to see you. God bless you. Amen.
Okay, so now, just to point out that for a share capital company, you know, it's possible for two persons to own shares in a company jointly. I don't know if I pointed out that when we look at the Memorandum of Association under section 27, but it's possible that two persons can own one share. And if they do that, both of them are joint members. So if it is Callistus and Adigio, it is only Callistus' name that will be there. Are you with me? Adigio's name will not be there, but both of them are joint members and all that. And so I just wanted you to point out. Because if you look at section 106, subsection 3, in the case of the company having a share capital, each member is a shareholder of the company and shall hold at least one share, except in relation to a company that has only one shareholder, except in relation to a company that has only one shareholder. Okay, can we continue, please?
Yes, sir.
Good. I'll come back to that. There's still some explanation I need to do. Now, let's look at capacity to become a member of a company quickly. You already know from formation of companies you already know that certain persons cannot join in the formation of companies. Yes. Example? No, this madam is the one I'm asking. Example?
An insane person.
And?
Insane person.
No, you will not say insane. You will say a person who has mental infirmity and has been so declared by a court in Nigeria or else. That is the difference between the A and the C students now. Somebody say infant. You do not say infant in the exam. You say a person under the age of what? 18. If you say infant, I know you have an idea, so I give you half mark. So please be accurate. Who else, sir? Number 3. Yes, my daughter. Who else cannot join the formation of the company?
A company in liquidation.
Yes, a corporate body under liquidation. A corporate body, not a company, a corporate body. But of course, we know what you mean. Number 4. Beautiful. An undischarged bankrupt. Once, who is an undischarged bankrupt? Yes, please.
Based on the lesson, there is somebody that has not been freed by the court.
Okay. Somebody who has sought. I hope you are not reading anything. It's not time to read. It's time to focus. Is it not so?
Yes, sir.
When you go home, you read. Good. So, a person who has sought protection under the bankruptcy proceedings. Are you with me?
Yes,
they want to. Your creditors want to feast on you. You are allowed to enjoy certain protections in law under bankruptcy proceedings. But to do that, you first of all declare that, my Lord, I'm bankrupt. And from that time, you become bankrupt. So a time may come when you become discharged, in which case you are not able to settle your creditors. Until such a time when you are able to do that, you are still declared bankrupt. And so the law puts a cap on you, a limit on you. There are certain things you cannot do because you are a bankrupt person. You have already shown that you are highly incapable of managing your finances. Are you with me? Such a person should not join in forming a company. Because if he joins in forming the company, he's likely to be a promoter. Are you with me? He's likely to be a promoter, and so he's likely to be in a very powerful position to even take advantage of subsequent members. And so generally we say such persons should not join in formation. Yes, the last one.
Director under section 1. Director.
Which director?
Director, there's a clause there. Director under section.
Excellent. So now there's a little problem there. You know, under KAMA 1990, under the Companies and Allied Matters Act 1990, please look up.
Yes, sir.
Sit properly. Keep your hand down. Yes. You're not in your house. Eh? Okay. But focus. Be disciplined. Be orderly. Can we continue?
Yes, sir.
You don't go to court and sit like that. I've told you, treat here like a man. If it's too bad, treat here like a magistrate court. If you go to court, you don't look at your phone. You don't answer phone call. You are orderly. You don't answer the court, yeah. You don't answer the magistrate, yeah. It's yes. It's not yeah. Prayer is what?
Yes.
Yes. So take that kind of respect whenever you come to my class. Because most of the magistrates, or a number of those magistrates, I taught them.
Yes, sir.
Are you with me?
Yes, sir.
Good people. Success. Can I continue? Okay, so now, under KAMA 1990, a director disqualified under section 254 cannot join in the formation of a company for fraud-related problems. You know, so under that section, if a director is convicted, a person is convicted either as a promoter, a manager of the company, a director of the company, and they discover that it's fraudulent, they can disqualify him for 10 years. During the period of that disqualification, he cannot join in forming a company. CAMA 2020, like I have said before, is riddled with a lot of errors. Is riddled with so many flaws. And this is one of them. I'm trying to compile all of them to send to Corporate Affairs Commission. If you look at section 20, subsection 1D, they intended to refer to a director disqualified under section 280. Because section 280 is in pari material, exactly the same thing with section 254 of CAMA 1990. Are you with me? Yes. They went to put section 281. Somebody should read section 281 for us quickly. Let's not waste time on this matter. Brilliant. You have always been reading, so now you can read. Quickly, 281.
Person may be appointed director for life, provided that it shall be removable under.
You can see that. It does not have to do with disqualification. Yes, so come and say a director disqualified under section 281. Section 281 says a person can be appointed as a director for life. So definitely that's not what they intended. What they intended was section 280, which deals with disqualification of directors. So those are things we just don't know how to work out. But I'm compiling all these errors and I want to send it to them. Okay. So now when we come over to membership of companies, which is our focus today, the same persons who are disqualified from joining in the formation of companies are also disqualified from being members of companies. Apart from these directors. Apart from directors disqualified, every other person that cannot join in forming a company can also not join in being a member. Yeah. So remember, a person, an infant under 18, his own disqualification is conditional. It's not absolute.
Yes, sir.
Yes. What is the condition, Mr. Kokowa?
Whereby others that are of age, one or two persons that are of age, you can join them.
Good. Good. So for a multi-member company, a company with 2 or more members, provided we have 2 capable adults, he can join. But other than that, he cannot. The same, a foreign company can also join, provided it complies with certain conditions and all that. So when we come over to section 106 of CAMA, we see a virtual reproduction. It's not absolute, but a virtual reproduction of section 20. To the extent that a person who has been declared by a court, judicially declared to be of unsound mind, cannot join the formation of a company. Of course, subsequently, he may be cured of that infirmity, in which case he can join. So it's not forever. Are you with me?
Yes, sir.
Yes, all of these persons, their disqualifications are not forever. The same way an undischarged bankrupt can subsequently be disqualified, can subsequently be cured of that problem. Then he can join. A person under 18, of course, he can become 19. He can join. A corporate body in liquidation also. A company can, the liquidation process can commence and subsequently it is reversed. So we can start liquidating a company. The moment we start, that company cannot join in forming another company because it's being wound up. But as the liquidation process is going on, the company could be rescued. Particularly now that Nigeria has introduced corporate rescue mechanisms like voluntary CVAs, companies voluntary arrangements and administration. So if the company is rescued and the whole liquidation process is averted, then it can also join. I hope that is clear enough. Yes. The only thing CAMA doesn't insert here are directors disqualified. So under section 20, a disqualified director cannot join in forming a company. But under section 106, he can be a member of a company. Ask me why.
Why?
I think the idea is because disqualification from directorship or fraud-related instances should justifiably be a ground to stop you from joining the formation of a company because you have already proven that you're a fraudulent person. You should not promote or midwife a company. But that should also not disentitle you from a right to own property. The right to own shares is a right to own what? Property. And so that you're a convict does not mean you shouldn't acquire assets. That is the whole idea. That is the reason why that one is removed. So even though you have been convicted and disqualified for 10 years, you can still buy shares in a company. You can't manage, you can't direct, you can't join in forming a company, because those are very, what you call, pointers of influence, promotion, joining in the formation, management, directorship. Are you with me? So as long as you have been convicted and disqualified, you cannot do any of these major pointers. But that doesn't mean you cannot own these assets. So you can buy shares still in companies. That's what we're saying. Now again, another thing I want to point out is that what happens if I now decide to sell my shares to a person who is an undischarged bankrupt? I may not have known, but it doesn't show in his face. Because if a company is coming to the public for the first time through an IPO, initial public offer, UBA is coming to the public for the first time and they're bringing an IPO, they want to raise 50 billion naira. So the public is hereby invited to subscribe for shares. And a disqualified person or someone who is mentally infirm now decides to go to a stockbroker and he fills those forms and pays the money. What happens? Karma provides that where such is the case, upon discovery, his shares will automatically devolve in. Look at sub 5, please. Look at sub 5. Let somebody read again.
106 sub 5.
Yes, please.
Where after the commencement of this act, any shareholder proposed to transfer any shares or shares to a person falling within the provisions of subsection 1. The purported transfer shall not bear the title in the shares in that person, but the title remains in the purported transferor or his personal representative who holds the share in trust for that person during the period of the act.
Good. So in the case of transfer from one shareholder to the other, you transfer your shares to a person who is incapable of being a member, then the transfer will not actually go through. The transferor will still be deemed to be the legal owner of the shares. Of course, you'll be holding them on trust for the person. So automatically becomes a trustee. Is it resulting trust or so they call it?
Yes.
Those of you who just did trust, is it resulting trust?
Yes.
Good. Are you sure?
Yes, sir.
Yeah, I'm not sure. That's why I'm asking you. But I know it should be resulting trust. Okay, so let's continue. But the issue now is that this subsection doesn't deal with the company itself issuing you shares. So there's a lacuna to that extent. So the subsection is saying if Walson transfers his shares to somebody who has been judicially declared to be of unsound mind, those shares will not move. What if it is UBA Nigeria Limited that issues shares to somebody who is judicially confirmed to be mentally unsound? Will the shares return back to the company? Will the company hold the shares on trust for the person? Look at sub 4. Read for us.
Where at the commencement of this act, any person falling within the provisions of subsection 1 is a member of the company by reason of being a shareholder of the company, his shares vest in his committee of trustees.
Okay, now again, this subsection appears to address that lacuna, but it's not entirely, because here we now see where at. So the idea is that Karma came into force, I think, in December 2020. It was enacted in July, but I think it came into force in December. I'm not 100% sure on that. But let's assume Karma came into force 1st of July 2020. If upon that date, shares in a company, let's say UBA Nigeria Limited, were held by a particular person who is judicially infirm, then automatically those shares that were held by him will be vested in his committee or trustee. Okogbo, please come and sit here. Thank you. Take your things. Are you with me so far, my young friends?
Yes, sir.
Excellent. So I think what should have been inserted was where at the commencement of this act or after. Because if you look at subsection 5, they said where after. I think that is better, but here they say where at, but That is just an academic, and don't mind us. We like to dance around these things. Let's move on. Are there questions so far, please? Let's look at rights of membership. What are the rights? Rights of membership. Well, I'll run through some of them. General rights, which we all know. First of all, there are statutory rights, and then there are contractual rights. These contractual rights could be inserted in the memorandum of association, in the articles of association, basically in the articles actually, and in any other document. So there are contractual rights which could be inserted basically in the articles or in any other document, any other contracts, I mean. Then we have statutory rights. The statutory rights, most of which are contained, of course, we know in CAMA. There could be others in other laws, banking laws, insurance laws. But for this our purpose, let's focus with CAMA. So we'll run through some of the statutory rights. You just to run through some of them. Of course, there's the right to attend meetings. And some of these rights, again, sorry, you can look up again, some of these rights are inalienable. Some of these rights, particularly the statutory rights, some of them are inalienable. So even the member himself cannot shake them off. He cannot waive them. That's what we are saying. He cannot waive them by contract. So we have inalienable rights. Then we have rights that can be waived by contract, basically in the articles and all that. Can we flow? Good people. So I'll run through them. Of course, there's the right to attend meetings, the right to speak at meetings, the right to vote at meetings. So I cannot enter into a contract with Adigio Nigeria Limited to say from henceforth, having collected 1 million naira from you, I cannot speak at meetings. I cannot attend meetings. I cannot. Are you with me? Yes, it's not allowed. Their absolute right is be made. The right to attend meetings, right to speak at meetings, right to vote at meetings. For share capital companies, we already know that there's a right to capital in the event of liquidation, and there's a right to income. You remember?
Yes, sir.
Priya, you remember?
Yes.
For the guarantee company, there's no right to income, there's no right to capital. But for the share capital company, we have those rights. Another thing just to point out is that if you look at section 107, the proviso there, please somebody read for me again.
Provided that
Yes, please.
the articles will provide that the member shall not be entitled to attend and vote unless all costs or other sums payable by him in respect of shares in the company are
Good. So that right to attend and vote could be for share capital companies, could be subjected to a condition inserted in the articles. That was if you don't pay for your shares, when we call you to pay for them, and you are telling us stories, then we can sanction you by not allowing you to have a role in governance, because your right to vote and your right to attend meetings, those are your governance rights. Are you with me? So every member of a company should have a stake in governance through the members in general what? Meeting. But that right can be curtailed if you have not given us your own proportional financial and commitments. And it makes sense. It does make sense. Let's run. There's the right to receive dividends when declared by the board. There's the right to transfer your shares. There's the right to receive upon request certain statutory books and records of the company. There's the right to inspect statutory registers. There's the right to petition for a winding up. There's the right to seek for an investigation into. There are a number of them. There's the right to receive notices of meetings. There's the right to demand poll and appoint proxies in company meetings. There's the right to take up minority action if your rights are being infringed upon. There's the right to requisition for extraordinary general meetings. And there's the right to be issued certificates or share certificates and all that. Another thing I want to point out is that some of these rights, again, while they are conferred upon members, can only be exercised in conjunction with other members, or you must have a particular threshold of interest in the company to be able to exercise some of these rights. So not all these rights can be exercised by a single member, except that single member has interest in the company that have reached a particular threshold. Let me explain. The extraordinary general meeting, for example, if there's problem going on in the company, and I feel that the directors are not acting the way they ought to, and I want the members to be involved, to be aware. My friend, focus, Jessica, focus. I don't know what the four of you are doing. Focus. Can we continue?
Yes, sir.
So I feel that the directors ought to take action, and they have probably been negligent, or they've all traveled. Then I may decide to call for an EGM, extraordinary general meeting. But because of the importance of that particular decision, to call a meeting is very expensive. Are you with me? Yes, you have to hire a venue, you have to put logistics in place, and it will amount to millions. The law provides that the person that can call for this meeting must be up to a particular number of members. If it's a share capital company, their interest together must be up to, I think, 10% or 15%. We'll come to meeting soon. They must reach a particular. So that is not an interest that a single shareholder can just exercise. Are you with me? Except his interest is very significant. Otherwise, he will have to look for other members. And by the time you collate all their interest in the company, it must reach that 10%. Then he can exercise that right. Now, for a non-share capital company, no matter how much you are put in the company, your interest, as far as governance, is limited to just one person. 23 of us set up a company for the promotion of religion, let's say a church. And I'm the greatest seed sower. You know, they say sow seed. You know what I mean? Yes. Good. From the time we started this church, I've been the one consistently, no matter how much you sow, like sell your house, sell your car, sell your bed, and you put in that ministry. When we come to governance, your stake is just one. Because in that case, like I said, it's not a share capital entity. It's not an entity from which you expect to benefit. Are you with me? And so company law does not allow you, when it comes to governance, to have a greater right over PRIE, who probably does not give offering, does not pay tithes. Doesn't, and you know we have church members like that. One kobo they don't contribute. They are the ones who even cause problem more. A dime they don't give. As in a dime. I mean a dime. Some of you are like that too. A kobo you don't give. And they are the ones causing men of God more. Those ones who don't give a kobo are the ones fighting men of God on social media. Go and check, they don't pay tithes. Those who give, they don't even say anything. Can we continue?
Yes, sir.
Excellent. I said all of that to say that. Again, I talked about when a company decides to alter its memorandum to change the business clause or the objects clause, that certain members can object. For them to object, they must reach a certain percentage. So it's not just an automatic right that every member can quickly go and rush to court. That's what I'm trying to say. Let's come back to where we are, because we have taken a lot of time. Okay, so contractual rights, I said, could be inserted in the company's constitution or in any other document, and if we insert anything you want to insert. Could, for example, confer on a member the right to appoint directors. The articles could provide that PRIE is the person that has the right to appoint the managing director. It becomes a right, you know, and all that. Let's move on. Please see section 108 because of time. It's an offense to impersonate a member. It's an offense to impersonate a member, and if you do so, you could be convicted and sentenced for up to 7 years, or you could be required to pay a fine. The court convicting you may, as an alternative, require you to pay a fine. The Corporate Affairs Commission may additionally impose a fine on you, and lastly, the aggrieved member himself may require you to account to him for any benefit probably you have gained during the period of that impersonation. There are some authorities I've given here. Please look at them when I send you the slides with respect to infants, persons under 18 and all that. And most of them are common law related. You remember them from your law of contract. That most contracts that infants enter into, except they are for necessaries, are generally what? Voidable. No, not void. They are generally voidable at his instance, except he cancels them, he renounces them. There's a word I'm looking for. Repudiates them, upon attaining majority. Is it not so? Yes. Upon a reasonable period after he attains majority. So that those principles also are brought to bear in company law. So you see the case of Steinberg versus Scala, Steinberg versus Scala. You see it when I send you my slides. Okay, so how do we acquire membership? I've already said it, but I just want to still emphasize it again. How do you acquire membership? You can acquire membership directly or indirectly. Directly or indirectly. Please look up. You acquire membership directly when you deal directly with the company. And this could be done in two ways I've already explained. Number one, by subscribing to the memorandum. Number two, by agreeing in writing and your name being entered into the register of members. That is the direct way of being a member. The indirect way is that the company has no relationship with you. Rather, you acquire your interest in the company from somebody who already has an interest in the company. So, if this is my daughter, what is that your good name? Aboye. Good. If my daughter Aboye has 10 shares in UBA Nigeria Limited, she can sell those shares to Success, or she may decide to sell half of them. The moment she does that, Success automatically acquires the right to be a member in the company. So that is an indirect transaction. We don't necessarily need to know what they are doing. All we need to confirm is that the documentation between them, was it done willfully, deliberately. Once we are sure, then the share certificate that she has issued to her, we'll take it from her. Are you with me? And then we enter her name in the register of members. So that, I want you to note that indirectly. So it could be done by transfer. Secondly, it could be done by operation of law. By operation of law. We are looking at the indirect way of acquiring membership. It could be done by operation of law. And by operation of law, we are basically looking at transmission of shares. Why is everybody looking at the window? You too, you are looking. I will send you here like that man. You left your house to look at me. Now that you are looking at me, you are looking at the window. Can we continue?
Yes, sir.
Good people. Okay, so operation of law, let me explain again. Transfer is a voluntary transaction entered into between shareholder 1 and shareholder 2. And presumably it is done in pursuance to a contract of sale. So we presume that Aboye is selling her shares to Success. It mustn't be a sale, it could be a gift. Are you with me? So either it's a sale or it's a gift, whatever, that is a business. That is a transfer. When we come to the transmission, on the other hand, it could happen in two ways. If she is bankrupt, God forbid, somebody say God forbid.
God forbid.
If she is bankrupt, God forbid, then her shares will, by operation of law, transmit to her creditors. So here it's an involuntary transaction. She's not necessarily happy about it, but she's bankrupt, God forbid. And then shares have moved. That is one aspect. God forbid, if the shareholder dies and he has shares, then those shares are also likely to transmit to his heirs. Are you with me? But before they ultimately get to his heirs, they will first of all fall to his personal representative. If he made a will before he died, then that person will be called an executor. If he died without making a will, in which case we say he died intestate, that person is usually called an administrator. So if he made a will, we will say it was not an involuntary transmission, it was a voluntary transmission because he made a will. Upon my disease, let all my shares fall to my wife. That is voluntary, but it happened upon his death. If he never made a will, then by operation of administration of estates law again, we will now cause those assets to devolve upon his heirs and heiresses as the case may be. Are you with me? There's priorities, also. Excellent man. Yes, my dear.
So, in case he made a will, could that be said it is transfer, but not transmission?
It's called transmission. That is what the law calls it. The whole idea, of course, you could call it transfer. For the layman's term, you could call it transfer, you could call it transmission. But for us who are doing company law, the law itself uses the word transmission. Are you with me? So if it's bankruptcy, if it is death, the law calls it transmission. But if it is two persons who are alive, and oh boy, I need money, I'm relocating from Nigeria, buying my shares, okay, they will call it transfer. Okay, so I've said all of that to say that. Okay, operation of law, again, I said bankruptcy, again, insanity. The person becomes insane, and is incapable of managing his affairs. His assets are again likely to be transmitted to a trustee, committee, as the case may be, who of course will hold those interests in trust for him. Let's move on. Okay, so yes, so just to point out again that at the root of a person becoming a member of a company is his own will. He must be willing. You can't do it automatically. You cannot just come and tell me that and your father died, he has transmitted shares to you, you are now a member of this company. I could decide not to. Is it not so? Yes, so a person can reject the gift. I know of a lady whose father had earned all his inheritance from alcohol. Those were in the days of what we call the temperance movement. And when he died and he left his huge inheritance to her, she rejected it. Just to point that out. When your father has earned all his funds from cutting people's neck, being a major ritualist, you may want to reject such inheritance. Is it not so? Yes. Good. In order for it not to mar your own inheritance at all. It wasn't illegal, but some people felt it was wrong. That was in America anyway. Okay, let's move on, please. Now, let's just talk. Please look at Starcola Nigeria Limited. Starcola is a popular case you keep coming across. It's Starcola versus Adeniji, or Starcola Nigeria Limited and another versus Adeniji. Again, you see it when I send you the slide. That case had to do with promoters. Is a promoter automatically entitled to be a member? No. You cannot force a company to make you a member because you had done so much. So this guy, he had helped the company, he had midwifed the company. And when the company was finally incorporated, the shareholders were very happy with him and promised him that they will make him a shareholder. But there was no definite contract to that effect. And so when he felt aggrieved and he went to court, he could not win the matter. So a promoter is not automatically entitled to become, to shares in the company. Please note that. Now let's talk briefly. I don't think we'll finish this class today because I'm just in slide 14 and we have up to 44 slides. And this is 1:32 and our class is till 2 o'clock. Is it not so? Yes. So we'll have to adjourn. When we get to 2, we have to adjourn. Okay, let's talk briefly about proof of ownership. Proof of membership. before we come to proof of membership, two things I want to point out. First of all is that if you notice our focus has been on share capital companies. And I said most of the rules applicable to share capital companies will also apply to non-share capital companies, but not entirely the same. For example, in a guarantee company, you cannot transfer your membership to another person. Are you with me? In a share capital company, you can, because you have a definite interest in that company. So if you set up a church, for example, the law requires that we should have a board, an executive authority, trustees, and all that. That's if it was an incorporated trustees. But if you set up a guarantee company to promote religion, to promote arts or culture, as the case may be, you have members. Let's assume you have 5 members, and you want to retire after some points. You do not have an automatic right in law to transfer your stake in that company as a member to another person. But for the company, you can, by simply selling your shares. So it's important that we always are conscious of these facts. So first we want to look at, with respect to share capital companies, there could be disputes with respect to, first of all, shares. Who is entitled to shares in a company? I could sell my shares to this man, Kubo Kurowe, receive money from him, and undertake to issue to him the share certificate and the contract of sale, with which he will go to the company. The company will now remove my name and insert his name. Having taken his money for the number of shares I want to sell for him, I decide to change my mind. I'll breach the contract, is it not so? And so he could bring an action, first of all, to establish his entitlement to those shares. Then, secondly, to ask that his name be entered into the register of members. So, in which case, the first thing he wants to prove is not his membership, but his entitlement to shares. So, it is first of all the shares that will now give you a right to membership. Shareholding is not synonymous with membership. It's crucial that we establish that. It's not. So you can be a shareholder and your name is not in the register of members. You are not a member. Yes. But being a shareholder entitles you to be a member. And so if you have now become a shareholder and the company says they don't like your face, they don't like you, you are too cantankerous, you are too troublesome. So Walson has sold his shares to Kubo, but we don't like him. Then we may decide not to enter his name in the register of members. Are you with me? Are you with me? In which case, Walson is still the member, but Kubo is entitled to his interests. And so Kubo will have to first of all prove his entitlement to those shares. And then he will have to compel, through the courts, he will have to compel the company to enter his name in the register. It is only when his name has entered the register that we can now say Kubo is a member of the company. So please, I want you to note that. So after that, a document will be given to him called a share certificate. A share certificate. This document is usually given by the company. It could also be given by the person selling. So if Aboye is selling, or she has 10 shares and she's selling the 10 shares to Success, then she could give her share certificate to Success. When she gives that share certificate to Success with the contract document, Success brings it to the company receives both of them, cancels that share certificate, and gives her a new one, carrying her name. In the other instance, she has 10 shares and she's selling 5, she's retaining 5. Are you with me? In which case, she will not give her the share certificate. Having entered into the contract of sale, she will come to the company will receive this document, cancel it, and reissue how many? 2. One bearing her name, one bearing her name. But all of these things don't happen in practice. So ask me why. Because particularly for public companies, shares are now being held in a dematerialized form. We have a company called CSCS, Central Securities Central Securities Clearing, blah blah blah, CS. So what the world is doing now is that share certificates are held in the materialized form. They are held online, virtually. Are you with me? They will not be sending you share certificates. You go to your post office box and you open it and you see some pile of documents. It used to happen before, but we are moving away from that. But the law still provides for it, so we have to teach it. But in practice, if you start to acquire shares, you are very unlikely to have these real share certificates. They could give you, but you could still insist on them anyway. Let's move on. How do you prove, therefore, that you are entitled to shares? You prove it the way you normally prove any other thing, because by balance of what? Probabilities. Is it also? Preponderance of what? Evidence. So you mustn't, it could be orally. Oral evidence is accepted, yes? It could be primary evidence or what? Or what? Secondary. Yes, so the normal way, preponderance of evidence or on the balance of probability. So the normal way you establish your matter in court is the same way you have to prove your entitlement to shares in a company. The company may have decided to write to you, or they may have even spoken to you orally. Say, if you have taken your money and we have issued you, you have been allotted 20 shares in a company, and subsequently they renege. You could still prove by oral evidence that indeed that was the transaction. And if the court believes you, then automatically you'll be deemed to be holders of those shares. Of course, you know the burden of proof. Who does it lie with? The person who has that and all that. So you all know that now. But of course, the best evidence will always be more helpful. And the best evidence is when you bring what? Beautiful people. Documentary evidence. Just a minute. Okay, so I think we will, let's just see how far we can just touch the next 20 minutes, and then I will have to, because something urgent just came up. Are there questions? No questions, because I'm doing a very perfect job. Is it not so? This is job man is trying. Yeah. Okay, so let's pause today. Can we meet tomorrow? Yes, sir. What time? About it. You will reach me and tell me the time. We must meet tomorrow because Wednesday is out of it. Thursday is likely to be out of it, but we can still meet Wednesday. Okay, so you can put it off. We meet Wednesday, 7 o'clock in the morning. No, my